Please, my lords. I'll make one final submission, in this issue of the measurability of the cost. If the JPS had included the costs resulting from the IDT award in its 2004 application, that expense would have been taken into account in the rate fixing exercise for the next period and would have been awarded.
How would that have been done? I mean, I can see they would have taken account of the ongoing salary increase. But what about the back pay? How would that have been brought into account?
Well, any liability which is incurred and which is a properly legally incurred cost would be claimable as part of...
But I mean, the back pay, which was effective as from 2001, according to the decision, and is a sort of substantial sum, how do you bring that into the standard rate? I mean, it has to be sort of spread over some period.
Yeah, the OER would be responsible for doing that adjustment. The important thing is that the fact that they have incurred that expense would be taken into account, and that would be included in the operating costs, which would be assessed on the basis of what is attributable to the test year. Once that has been done and the rate is fixed, then the office doesn't have the capacity to keep changing rates. It can only do so on the basis of the scheme.
But I mean, point I'm making is I can see that what's attributable to the test year is the increase in pay resulting from the award. But that doesn't deal with the back pay. You've got a substantial sum of the pay going back to 2001. And how does that come into the test year?
It is an expense properly incurred in the test year. Yes.
But it's, so not, incurred. It's not incurred in the test year. It's eventually incurred in 2008, but it was in fact effective from 2001. So it's not. It has no connection to the test year at all.
If you load it all into the test year, you're loading in, 3 years into 1 year. Does that mean you get the inflated rate for the remaining 4 years of the 5-year quinquennial period, or for all 5 years, the quinquennial period? Or does the test year operate only for the first year of the quinquennial period, and then there's some provision for reduction in later years?
Well, I wondered whether in page 32, where they discuss the test year and the adjustments, in 2, they talk about changes to revenues and costs, which presumably are annual costs, but they also talk about extraordinary or exceptional items. Would the back payment qualify as an extraordinary or exceptional item, which then would be amortized over several years?
Perhaps that's it.
Yes, I think I would respectfully accept that, yes.
Yeah. So how does it work for the future?
Well, in the future,
the future is now past.
There are 2 possibilities. That is, in this particular case.
Yes. What happened in 2009?
Well,
did they manage to get the increase then?
In 2009, it would have been affirmed that the liability existed as determined by the IDT award. And therefore, the test year, which would have been used at that time, would include the increased salary scales. But let us take the other assumption, namely that the IDT award was set aside in the interim period. They would still have the benefit of the fact that it had been included and the rates had been fixed over the next rate fixing period.
Well, that would be very odd. Well, I suppose
it would be to their advantage.
They would have paid it. They would have paid them so that it wouldn't be so odd.
It would be. The only ultimate result is that the requirement for revenue which is part of the rate, an essential part of the rate fixing exercise, would be reduced by reason of the fact that they had got these amounts which they ought not to have got.
The requirement for revenue for which period?
For the new period.
For the next 5 years?
For the new next period.
But supposing that the 5-year rates have been fixed on the basis of some notional calculation of the costs, right? And then after 2.5 years, the appeal succeeded and it was held that the company no longer needed to pay on the basis of the 5 to 10% percentile, but could pay at a lower rate. There'd be no means of redress of that.
No, there would have been no recovery from the company. And that is not, one has to remember that in a rate fixing exercise, you are projecting things and assuming that certain things will result in a certain rate of return on the investment. Yeah. And these might change during the period. And there is no method of retrospectively fixing the rates so as to change the rates chargeable to the public. But what you do is in the new period, that will be taken into account and any adjustments necessary could be effected.
Subject to the Z factor, within the 5 years, it swings and roundabouts.
Indeed, Your Honor.
How do you reconcile, just changing the point, how do you reconcile the findings about condition C of the Z factor and the findings you rely on to the effect that these sums could and should have been included in the 5-year calculation?
There are 3 conditions in the Z factor application. And the third is that the particular event is not captured by other elements of the price cap mechanism. Our submission, of course, is that the particular events, namely the IDT award, which increased the salaries for the staff, would be captured by the ordinary price cap mechanism, because that would be a cost.
But you lost on that, and it's been held that they aren't captured. So how's that consistent with your case that they've also found that these, or the office and possibly the tribunal also found that the sums are reasonably measurable with reasonable accuracy, in which case they would be captured?
I'm wondering whether the possible answer is this, that are not captured could be interpreted as meaning capable of being captured, or could mean aren't in fact captured. If you take the second reading, it's a provision against double counting. And the only way I can make sense of the tribunal's reference to C being satisfied is on that basis, that there wouldn't actually be any double counting. If it's to be construed as capable of falling within the mechanism of the scheme as properly applied, then if that's what they meant, there is indeed a total self-contradiction within a very small number of pages.
I respectfully accept that as a reasonable construction of the 3 conditions.
But it's most unlikely that they introduced a condition which depended upon what the party chose to do, isn't it? I mean, on the face of it, it's and it means are not within the other elements.
No, but if we're trying to understand the thinking of
the thinking of the tribunal must have been erroneous on that basis. Yes, quite.
But surely the intention of the creators of this license was that there should be no double counting, so to speak. And that,
Well, I think the intention was to create a sensible scheme, and one would have thought that what the C was saying is, if you're within the other elements of the price cap, of course you can't claim something that
that is what
should
I
have
mean
been
by
within the
double
price
counting.
cap.
Yes, very well. So,
Anyway, but it appears the... Okay, right.
please, well, it's,
Thank you very much indeed. Yes. Miss Lindsay. Thank you very much. Yes, Madam Attorney.
May it please you, my lords. Although the agreement was for Dr. Barnett to deal primarily with the second agreed issue, it was subject to my adding comments where necessary, and I would ask your lordship whether you deem it necessary for me to add my comments.
But I think you have to form that judgment.
Very well. Well, my lord, let me begin generally by saying that this matter has huge implications. It's really...
Well, there's a lot of money involved.
It's a big money case.
Yes.
Yes, yes, my lord, and it does have a huge implication. In fact, the company puts the electricity rate increase that would result, should it succeed, at approximately 40% for the typical residential consumer.
Yes.
40?
40%.
Thought it was 0.4.
It would be 100. Yes, it would be 40%.
Where's that?
106.
106?
106 of the record. And that is not even the end of the matter.
Let's just find it.
Hang on, it's 0.4% on.
0.4%.
No, yes, 0.4%.
Yes.
It's yes, 0.4% of 1%.
Yes, it's not 40%.
Right. No, it's not 40%.
No, it's quite a lot less.
4%. But still huge in respect of...
Well, I'm not sure. Yes.
Yes, yes. 0.4%, but...
Well,
still
I hope we've reduced the significance of this matter.
Well, that's not the end of it, my lord. It's 6.75 cents per kilowatt. And then there would be a 100% foreign exchange factor to be applied to the Z factor.
Yes.
And that is on the opposite page at 107.
Yes.
And this would be for how long? This would be for what period? Just for 2 years? July 2009 to June 2011, is that right? Looking
Appears-
middle of page 106.
Yes. Yes.
Over the, yes, 24 months. So that's a 0.4% raise for 24 months, but presumably the raise has occurred. There has been an increase, maybe not as much as this, because we're not catching up a number of years, from 2009 onwards, hasn't there? They're recovering, I assume, am I right, the full costs
The
from...
rates go up. The rates go up, my lord.
Yes, but can you answer the question, do you know, in the second 5-year calculation, these costs were included?
No, not these. These are
Not these costs. So,
these are the back pay, aren't they?
sorry, the raised costs.
The
new
continuing
schedule
liability
going
to
forward.
pay the new higher salaries currently and into the future will be built into the tariffs, won't it? The 0.4% is
Catching up for the past years.
catching up with the past.
Yes.
But can the size of the consequential costs affect either the interpretation of the licence or the question whether the sum was reasonably calculable?
No, my lord.
And also, if these were the proper costs of providing electricity in Jamaica, then there's no particular reason why they shouldn't be passed on to the consumer, are there?
As long as they were prudently incurred.
Well, there's no suggestion that they weren't, is there? Is there?
Well, my lord,
There's no suggestion that these weren't proper costs. There's arguments about how,
the costs
whether they should
were
have been paid
incurred.
sooner. Yeah.
Costs were incurred, but the ultimate,
So in a way, it's a windfall for the consumers of Jamaica if they avoid having to pay these costs.
It depends which consumers. I mean, one of your points is that if they're not charged in the right period, they potentially fall on the wrong people or different people, later people.
so, my lord, the point of that is just to direct your lordship's mind to the implication. And the cost would go up anyway in light of the mechanism that is in place. And in respect, the consequence for the company spoke of its dividends payment being deferred due to the funding of the IDT award.
Well, did it? Yes, where is that?
Page 105, my lord.
Yes.
But I mean, that's of no relevance
Again,
either.
quite. What's the relevance?
There's no hardship. We're not being told that there's such hardship they can't pay it. I mean, this has got nothing to do with the issue of construction, which I thought you were going to deal with.
But at the end of the day, my lord, the decision will have consequences, and I'm merely bringing it.
We're aware that you're here because it's going to have big consequences.
But
So
I think we like to hear the legal submissions.
Very, very well, my lord. So, as has already been indicated, the appeal has come by way of the exercise of the condition to appeal to the appeals tribunal from the decision of the OUR. And the issue has already been put forward that we're dealing with judicial review. And your lordships are very aware that in the realm of judicial review, contextualizing, my lord, that you are concerned with the legality of what was done by the body in question, not with the merits of the decision under review. And this, of course, is contrasted with an appeal where the question usually is whether the decision is right or wrong. Whereas here, the question on a judicial review is whether the decision is in accordance with the law. Your lordships are well aware of that. The two issues are interrelated, my lord. As has already been indicated, if the costs were known and if they were measurable with certainty, then they should have been included. If they were not known and could not have been measured, then we would go to the issue of whether the interpretation of managerial decision within the clause. Dr. Barnett has indicated, my lord, as well as counsel for the appellant, that JPS is contending that the costs were not known, they were not measurable with certainty at the time when it made the 2004 tariff review application. But we know that in 2003, the IDT found that the JPS had all the relevant data to implement the salary structure that accorded with what was agreed between itself and the company, between the company and the union. And the agreement took place against a certain backdrop, which I would just invite your lordship's attention to. A restructuring exercise was taking place, and it was important for the company to be able to recruit and retain staff at a certain level. And the pay package was critical to the company being able to do that. So in 2003, the IDT found that the JPS had all the relevant data to implement the salary structure that would accord with the agreement. And in fact, my lord...
You're saying the IDT found that?
Yes, my lord.
Where did it find this?
Page?
Page 97. I crave your lordship's indulgence. 97. Crave your lordship. They're finding the information. should have been implemented. The award indicated that the salary structure that should be implemented consequent is one that conforms with and maintain the established compensation philosophy.
Where are we looking at?
65.
Yes, that's on the question of whether, what the comparators are.
So the question, my lord, was not that there was no structure in place, but that they had in fact implemented a structure that had not accorded with what was agreed. So the structure that they had put in place would have placed it at a lower level as opposed to the higher level.
Yeah.
So it means that they had information on which they could have put a structure in place. It is just that the structure that they put in place did not accord with what was agreed.
So your position is that the KPMG report gave the necessary information for either the comparator which the company chose or the comparator which the IDT selected?
Indeed, my lord.
I rather read that into paragraph 30 of what I've called the Electricity Tribunal, to distinguish it from the IDT, which you'll find at page 201.
Indeed, my lord.
Which seems to suggest, contrary to what I'd originally thought,
From all indications, the information was there.
that the KPMG report,
The KPMG report contained all the relevant information from which a structure could have been derived, and a structure was indeed derived, only that it was not in accordance with what was agreed. Hence the dispute, and hence the matter that was referred to the IDT by the minister for resolution.
In this context, do you submit that the Court of Appeal got it right in their analysis at paragraph 59 onwards, page 378, where they look in some detail at what the KPMG report did and what remained to be done in the light of it?
Yes, my lord.
20137.
What was that page?
Page 378, paragraph 59
Yes.
onwards.
The KPMG report had in fact used the comparators which the IDT eventually said were the correct ones.
Indeed, my lord. And so it is critical.
It was the company that departed from it.
Indeed.
And going on page 380, paragraph 61, having identified a number of the issues that remain to be addressed post-KPMG,
Yes.
Court of Appeal say that these were essentially policy-related concerns. 4 or 5 lines from the bottom of the page, the Court agrees with Dr. Barnett. The correctness of the figures and the grading of the posts weren't challenged. Challenge wasn't to the empirical data, but to the hierarchical structural range of salaries. And then you come to this dispute as whether you take the top 5 to 10 percentile of the benchmark market or the different approach for which JPS have been considered.
Indeed, my lord. Indeed.
Yeah.
So
What is the R2? The report has not started, at the top of page 380, the report has not stated the R2 for any of the salary lines.
Well, the R2, I believe, it gives a measure of the spread of the salaries from the formula. That was something that, what Dr. Hamilton said, that not that it wasn't there, but it had not been disclosed.
Court of Appeal then went through the various grounds on which JPS said, well, there was residual uncertainty, making the figures not reasonably measurable, up to and including paragraph 66 at 384, where they addressed the main basis relied on by JPS, that it would have to ascertain what companies were within the top 5-10 percentile, and that a market survey would have to be conducted. That, the Court of Appeal concluded, wasn't supported by the facts. That actually it was perfectly doable if they wished to do so.
Indeed, my lord.
I mean, I see what the Court of Appeal says, but if one actually reads the top half of page 380, does one get the impression that one could do a mathematical calculation? I rather get the impression that there's quite a lot of room for bargaining and shimmying this way and that way, and ultimately it all depends on consensus according to points 4 and 6.
My Lord, the impression is that not the information that was made available in the report allowed for the calculation to be done, though questions were raised about certain things which had not been immediately discernible from it. But that did not prevent a salary structure from being calculated based on the data.
But not necessarily one that the unions are going to accept. Ultimately, this depends upon consensus, doesn't it? Otherwise, you've got continuing problems.
Well, you know, my Lord, that takes us back to what JPS, what the new shareholders inherited when they acquired the majority shareholding. And although Mr. Hilton conceded that they were not now viewing the majority shareholders as separate and apart from, as substituted for the company,
right,
you'd have seen the argument all along. It presented itself as if when Mirant acquired the majority shareholding, it was seeing itself as substituted for the company. But the company had existed long before, the manner in which the decisions were taken. So, my Lord, if we go to, your Lordship's in order, page 380, at paragraph 61. Items 3, 4, and 5 reflected the union's concern that their suggested pay structure was not in accordance with equity. However, it does not appear that there was any concern with the data that was obtained in relation to prevailing salary rates in other companies. They were all policy-related concerns. I therefore agree with Dr. Barnett that the correctness of the figures and the grading of the posts were not challenged. The challenge was not to the empirical data, but rather to the hierarchy structure or the range of salaries, which it seemed to me the unions were of the view did not reflect the compensation philosophy that had prevailed at the signing of the heads of agreement.
Well, that was the fundamental disagreement, yes.
Yes. But the point is that the data was there from which the structure to be agreed on could have been put in place. It's just that JPS departed and perhaps were unhappy with the industrial climate relations, thought it could have arrived at its decision without including the unions, without including the oversight committee. But the purpose of the committee in the first place, my Lord, was to bring a certain level of transparency and acceptability to the entire process. And so to take a decision that excluded them, you really were inviting trouble on yourself, knowing that once the IDT ruling is made, you would be bound in law to implement it. And this doesn't take away from any right you would have to challenge it via judicial review.
So you say the company could, without the unions and without the oversight committee or consultants, have arrived at a figure?
Yes, my Lord. But even so, you do recall that the committee was an internal structure of the company. So when the point was raised earlier that the company by itself could not have determined the figure, it needed the assistance of the oversight committee. The committee was part of the company's internal structure. At page 50, as part of the background, my lords, bring your attention to page 50. The critical role played by the committee and the unions.
Yes, the Court of Appeal addressed the point about the Oversight Committee.
Yes.
64, isn't it, page 382,
Yes,
and concludes that, bottom of the paragraph, the findings influence of the IGT makes it clear salary structure could have been calculated
Yes, my lord.
from the data or information presented by KPMG. And it's in this context that you remind us that we're not concerned with a conventional appeal. We're concerned with an appeal from a refusal of judicial review. The issue being whether there was a sufficient factual foundation to have enabled the tribunal to reach the conclusion that it did.
Indeed, my lord. The review is concerned, as your lordship has correctly said, not with the decision, but with the decision-making process. And in fact, my lord, unless that restriction on the power of the court is observed, the court will, in the view of Lord Brightman, in the North Wales Police and Evans case, in his view, under the guise of preventing an abuse of power, would itself be guilty of usurping power, were it to go otherwise.
Brightman can always be relied on for concern.
Thank you.
Takes us back a bit.
But
I think judicial review has moved on a bit since then.
Even in Lord Brightman's day, others possibly took a slightly less conservative approach, and not on that alone.
So, my lord, I believe what is critical is that the information was available. A structure could have been put in place. The amount could have been ascertained with certainty.
But I mean, you're going over ground. I mean, I thought you were going to tell us about managerial decisions.
Coming to that, my
your
lord.
point is well made.
I did ask for your lordship's guidance.
Your point is well made. We have to remember this is a judicial review exercise, and we can only overturn the findings of the courts below if there is no evidence to support their conclusion.
Well, it's surely the question is whether we are overturning the findings of whatever are the factual finding makers, who are either the office or the appeal tribunal. Yeah.
Well, my lord, I think your lordships are well aware of the uphill task that is faced by anyone who asks a court to overturn concurrent findings. But those findings have to be looked at again in the context of the judicial review jurisdiction. And the question is whether it would be reasonable or unreasonable. So in the face of the argument of the company, the tribunal found that there was sufficient facts in the possession of the company to calculate the cost with reasonable accuracy.
That's the key to your case, yes.
And in our view, such a finding of the first respondent was not unreasonable in this Wednesbury sense. The record shows.
I think the argument is that there wasn't much evidence for it. But you've given us some help.
And that's why the Court of Appeal spent some time looking at the material which had been before the IDT, having first ascertained that nobody was taking an objection in principle to looking at that material. So effectively what they've done is to widen the material which was being examined for the purpose of determining whether this was a rational decision, having cleared the ground by noting that nobody was objecting to looking at that material.
But the IDT had before it, my lords, 2000 to 2001 heads of agreement, page 53 of the record.
Yes, we've got that.
It had the KMPG report at page 51 of the record. It had oral evidence from Dr. Trevor Hamilton, who was a consultant for the company, JPS, page 55 of the record shows that. It also has the oral evidence of Mr. Wesley Nelson, if you see at page 55. It had oral evidence of Professor Gordon Shirley, again from the company. It had the minutes of the Oversight Committee meetings, pages 59, 60, and 61 of the records. And it had JPS's newsletter at page 56 of the records. So we submit that there was ample evidence before the IDT. And in fact, my lord, the IDT was praised in no uncertain manner and hailed as...
Sorry, can you just, when you say the IDT had all that before...
Material that was before the IDT?
Yeah, those are references to
I see. The page 53, my lord, the heads of agreement, 2001 to 2000. 2000-2001.
But you're not suggesting, I think we were focusing on the findings of fact made by the appeal tribunal.
I thought your lordship had asked about the sufficiency of the evidence that was before the IDT.
No, I mean, no one's challenging the IDT's decision.
No, it's the appeal tribunal, which is of interesting. And the appeal tribunal
But the
simply...
tribunal relied on what was before the IDT.
Yeah.
And the jurisdiction,
Well, it didn't have everything in front of it again. It
Yes,
had oral submissions only, didn't
Right.
it?
Yeah, but the Court of Appeal seemed to have treated without objection
Yeah.
the electricity tribunal, as we've called it, as having the relevant information which had been before the IDT. So I think we have to proceed on the basis that it was all there,
And there was-
which is your submission.
One can perhaps understand why an appellate court may be willing to do that in what they think is the interest of justice if it takes so many years to get from one tribunal to another. By the time it finally gets to the Court of Appeal, they would obviously not have wished to remit the thing to the original decision maker for want of full explanation if they felt that there was enough material that could be examined by them without injustice to the parties.
and for what it's worth, my lord, the IDT was hailed as a quality one tribunal of international standards.
We're not, no one's challenging the IDT.
Indeed.
We're-
But just to say, the conduct of the licensee
Did a very good job.
in terms of what it challenged and what it did not challenge, and what in effect would have been brought into issue.
Well, now, you've indented for an hour, and I think we've taken about half an hour nearly on a point which you're not primarily addressing us on.
Managerial decisions, my lord. On to the managerial decisions. I'm guided. So the Z factor, as your lordships are aware from what has been presented so far, is a factor under the PBRM, the performance-based rate fixing mechanism. It has already been indicated what has to be taken into account in determining, my lord, in its determination notice, the OUR determined that the appellant could not qualify under the Z factor clause to recover the costs associated because those costs were as a result of managerial decisions within the meaning of the Z factor clause. And in determining what the term managerial decisions refers to in the appellant's managerial decisions made prior to privatization, and whether the costs the appellants sought to recover using the Z factor were allowable, the tribunal at page 199 to 200 of the record identified a number of managerial decisions made by the JPS prior to the March 2002 rate review application. The 1991 decision to conduct a job
Well,
evaluation.
we can see that, and obviously if this isn't a correct approach to what is meant by managerial decisions, there are a lot of them,
Yes, my lord.
and they go back to as long, no doubt, as the company has existed, but certainly to 1990.
Right.
But is it the right approach? Can it really be the right approach? The Exhibit 1 operates, doesn't it, within the scheme of Schedule 3, which is a scheme involving quinquennial reviews, successive quinquennial reviews based on test year, each quinquennial review with some adjustments. So in that context, if you haven't managed to get something within the test year because it doesn't fall within it, then the Exhibit 1 offers a degree of flexibility at a subsequent annual adjustment. If you had got it within the test year, these costs would have been recoverable. That's your case, isn't it? Is it a bit odd if they aren't recoverable?
Determination would have been made as to what was recoverable and what wasn't.
Yes. Isn't it a bit odd that you can't have a parallel determination if the only reason why they weren't within the original test year and the original 5-year programme is that they weren't known and measurable with reasonable accuracy and weren't becoming effective within 12 months at the stage when the quinquennial programme and rate was set.
You know, my lord, the burden that is placed on the licensee that is contained in the license also speaks to the accounts that it should maintain
Yeah.
and what should go into those accounts for any given period. And those accounts also should be made public
Right.
after a certain time.
Yeah, but assume, contrary to your argument, that it wasn't known and reasonably ascertainable at the relevant time what these costs were. Assume, contrary to your argument, that that is the position. Then it would seem reasonable that these costs should be brought in at a later stage, I'd have thought. I mean, if you accept that in principle their costs
But they could
can be
only be recovered if they were not due to managerial decision.
You
And the
interpret,
Why?
managerial
What's the logic?
Yes.
They would be due to a managerial decision if they were known and measurable with reasonable accuracy at the time when the 5-year plan was prepared. So managerial decision would be no bar then. Why should the mere fact that they're not known and measurable at that stage make a managerial decision which predates the 5-year plan relevant when you come to the Z factor?
My lord, it is how the license is structured.
No, what's the logic though? One's got to think
To
of...
ensure that the costs to be ultimately borne by the consumer is borne in a timely way, and they are not accumulated over a period of time and then put before the OUR for approval.
can I just explore this from a slightly different angle? Your broad position, as I understand it, is that deciding to have a job reclassification is a managerial matter, and therefore all that flows from that flows from a managerial decision.
In part, my lord. So,
Let's just pause and think about that. Suppose that in the course of that job reclassification, Parliament passes an act which imposes a minimum wage far higher than that which anybody had anticipated. If I hadn't embarked on the job reclassification, they wouldn't have had to pay the higher wage. They wouldn't have been taking on the people to whom it applied. But would you say that a liability to pay wages imposed by statute comes from a managerial decision, namely the managerial decision to employ the person or classify their grade?
could, my lord.
Now, that can't be right,
but-
can it?
but-
Wouldn't the common sense, wouldn't the correct answer be that that which is imposed by the government isn't a liability that is due to a managerial decision in the real sense. It's due to
Legal.
a parliamentary intervention. And if that's the case in relation to liability imposed by statute, is there a difference in principle if a liability is imposed by a body under a statutory employment protection scheme? That is, say, the UDT. Get it right? IDT, sorry, I keep getting it wrong. We'll get ADT in a minute. ITT. If that's a statutory regulator and it imposes a liability, is the consequence really due to a managerial decision?
Here is how I would respond, my lord. If the licensee is obliged by law to make payments which would not have fallen for recovery in the normal structure of the license, then it would be viewed as a supervening event. And out of necessity to abide by the law, or to carry out the legal obligation, it would have to pay. And so we would pray in aid the doctrine of necessity and the supervening event of a law out of which the licensee would have no control, but which the scheme of the license would contemplate, could be recovered. So if Parliament were to pass an act which imposes a legal obligation on the licensee, to use your example, a minimum wage, which would be higher, then the licensee would have no option but to comply.
So that could come within a Z factor.
Yes.
But you say there's a distinction between a legal obligation imposed by Parliament and a legal obligation imposed by a body under a statutory scheme, an independent body under a statutory scheme, the IDT.
Well, my lord, the context in which the liability is incurred cannot be overlooked. And it's not necessarily that the liability was incurred as a result of the IDT award. It is because the dispute arose why the minister exercised the powers under the Industrial Relations Dispute Act and referred the matter. And that dispute really had to do with the structure, not whether additional payments needed to be made to deal with the wages. It was the structure that the licensee had put in place which deviated from what should have been agreed in the context of the industrial relations climate.
See, one approach to managerial decision could be that what is really being aimed at
And that is 2000.
are costs which are really the responsibility of the licensee itself, because they're a direct consequence of what the licensee has chosen to do.
Whereas these...
Yes, my lord.
Well, if that's right, I mean, the last thing it chose to do it was incur these costs. It resisted them. It says it excluded them because they were not measurable with reasonable accuracy, nothing. And it did nothing to make them measurable with reasonable accuracy. Can it really be said that it makes sense to talk of the emergence and crystallization of these costs as an event which was due to the licensee's managerial decision when it wasn't something that the managers wanted at any stage? They didn't take any decision after the quinquennial review. That's the sort of reasoning that creates problems for me.
My lord, the liability did not arise as a result of the IDT award. The liability arose out of the decision to reclassify.
Well, why didn't it arise out of the IDT award? I mean, one could argue that's precisely what it arose from. You say you've been making the point. The IDT award was binding in law and required immediate compliance.
Yes, my lord, but there is a certain context in which the negotiations take place. There is a certain context in which wages are settled, and there is a role that is played by the unions. The background, I believe, my lord, if you were to go to page 50 of the records. So, and I think...
And ultimately, you could trace everything back to a managerial decision to incorporate the company.
My lords, my lords. My lords.
Isn't what a managerial decision is aimed at is something which disturbs the equilibrium of the quinquennial programme, the review and the rate set by the quinquennial programme, in a way which is the responsibility of the management. It's their choice. Whereas here, they were dragged kicking and screaming. They resisted at every point.
Indeed. And
Well, how can it be, if that is the rationale, it sounds a bit, they couldn't originally, if they're right, introduce it in the quinquennial review, and thereafter they did everything to resist it. Why is it a managerial decision to incur it? To create the event, namely crystallize the liability?
my lord, I adopt in trying to answer your lordship, I adopt a view expressed by Justice Cook in the Court of Appeal, that at the heart of the dispute was...
Page?
I crave your lordship's indulgence.
We knocked you off course because you were going to take...
Yes, sorry, I knocked you out of
Page
course.
93, my lord.
Right, let's look at that and then we'll come back
I
to...
believe Justice Cook
Yes.
put his finger on the pulse at page 93. He said,
No. Which line is that?
93, my lord. I detect at the heart of this dispute between the appellant and the unions is that
They're not happy with the present labour relations
not
regime.
happy with the present labour relations regime. And so it took the decision, the management decision, as is shown at the minutes at page 59, the minutes of 9th May 2001, to change the chairmanship of the committee, the oversight committee, from Professor Shirley to a Miss Denise Toller, and also to have the project report to the HR department, and that the project was not a priority. And this is against the background.
But I don't quite understand. I mean, this might go to the question whether these were measurable with reasonable accuracy. It might, in other words, it might go to the question whether they were taking proper steps to crystallize their liabilities. But how does it go to the question, assuming they did take proper steps but couldn't quantify them, why does it go to the question of managerial decision?
Timing, my lord, timing. The time within which the exercise would have been completed for them to bring it within the 2004 review.
Well, it's the same point. It goes to the first point. Yes. Sorry, no, Lord Toulson, you were about to answer his point.
Well, I think, yes, I think you said you want to go to page 50, and then you...
Yes, my lord.
And then you got slightly knocked off course.
Right. So the point at page 50 in respect of the managerial decision that would affect the timing. So the committee is a critical part of the process, critical part of it. The same, and a critical part of the industrial relations climate.
No, but I thought the whole argument was that they're an irrelevant part and that the company should have assessed the costs irrespective of the committee.
My lord?
You say it's a critical part, but the argument we've heard earlier is that it's just a frill and you needn't worry about it and you could crystallize the costs yourself. The company could.
No, my lord.
No? Well, I misunderstood it.
Because at the end of the day, what was needed to be done was for the committee to be included in the process of arriving at the appropriate structure. Isn't it?
Running two also.
Yes. Yes.
That's a critical part of the management worker relationship. Yes.
Right. My lord, the committee's role was for the purpose of improving the industrial relations climate, but the committee also played a role in determining what the structure would have been. Because the committee comprised also of the unions. Earlier, when counsel for the appellant made his submission, he indicated that the company could not have calculated because it needed the assistance of the committee, with the consultants being part of it. Right. And the committee was relegated as a matter by virtue of a management decision. Yes, my lord.
It was relegated by management to a back seat.
Yes, my lord.
Right.
And in so doing, it had really resulted in an aggravation of the context in which the entire reclassification exercise and the pay structure, that entire exercise would have been completed.
right?
But the issue, as I understood it being argued, was not that the decisions were not managerial decisions, but whether they were pre-license or post-license decisions.
Well, I think we've
Moved.
probably indicated that we weren't wholly persuaded that that was necessarily the crucial cut-off date. The point which was certainly put was that this scheme operates by reference to 5-year periods. The annual uplift is something which is designed to take place within the 5-year period, possibly also bridging the gap between bridging 2 5-year periods, but we needn't worry about that for the moment. And that therefore you're looking for something which wasn't capable of inclusion in the original, but has become relevant during the 5-year period and is sufficiently unusual to fall within the Z factor. And the exclusions to the Z factor might, in that context, be taken to be exclusions relating to things happening within the 5-year period. That was the sort of point that was put, and wasn't entirely taken up, perhaps, by your opponent, but it was taken up in part, certainly. I mean, there are 2 possibilities. Another possibility, if one doesn't look at the precise 5-year period, is that one is looking at things which occurred after the March date when the 5-year rate is set. Because if one looks at the licence, it's set from the 31st of May, but it's set on the basis, as Lord Hodge pointed out earlier this morning, of a March date, isn't it? 1st of March, under page 32. You submit a filing with the office no later than the 1st of March, and thereafter on each succeeding 5th anniversary. So it may be that what is looked at in relation to the Z factor by managerial decisions are things occurring after and in the light of the filing on which the 5-year rate has been set. If you make a voluntary choice after that to something which you think of, well, that's your funeral. That's the sort of thinking.
But I would say, in addition to that, had the licensee respected the context in which this issue and the dispute had to be dealt with and the respective roles of the party, and it had the information available before it, it put in place a structure, except that it was not one that would accord with what should have been agreed and what would have been the philosophy at the time. Had it
respected the
Indeed,
philosophy, it wouldn't have got into all this trouble.
And thereafter, it took its own decision. And I think perhaps, my Lord, notwithstanding the concession made at the outset by counsel for the appellant, perhaps the majority shareholder, Mirant, was viewing itself as stepping in the place of the company and not respecting that the JPS school, which it owned, was the licensee. And that the decisions taken by JPS school, the licensee, needed to be honored. And that the applications for review had to be done in the context provided by the license. And they were not at large, simply because they might not have liked what they saw. Because if they took decisions that disrupted the regime, they would have to face the consequences and would not be able to recover. So, my Lord, our contention, which we ask your Lordship to accept and find, is that, firstly, that the liability was known and could have been measured with certainty from all indications. They had the material. They, in fact, came up with a structure. So they can't now say that I couldn't have done it when they did come up with a structure.
Do I understand your case correctly that Lord Mance has suggested that the principal purpose of the category B in the Z factor, that the exclusion of events which are due to a licensee's managerial decision, would be some voluntary incurring of cost in the 5-year period? Even if that is the principal aim, you are saying in any event it goes beyond that, and you say a managerial decision not to implement the IDC award and therefore not to include in the filing the claim is itself something. Those decisions are decisions which give rise to the event, namely the subsequent claim.
Your Lordship has put it correctly.
Yes. So you're saying you don't have to rely on the pre-license decisions. You say there is a decision shortly before the filing which gave rise to a disruption of the licensing system. Is that a fair summary of your position?
Yes, my Lord.
Thank you.
And that is why I said the two issues were interrelated.
But the other side of that coin is if there had been the managerial decision had been forced on them because they didn't have the relevant material to make the filing at the earlier stage, then presumably you would accept that that was forced on them by events other than a managerial decision.
I don't believe, my Lord, that that view would be supported by what is before us.
I mean, what I don't understand is why there must be some system for, the assumption of the definition of the test period and what's brought in is that there will be some sums which, though entirely reasonable, entirely proper, can't be estimated accurately at the beginning, at the relevant time. And so one assumes there must be some procedure for bringing those in at a later stage. And as far as I can see, the only method is the Z factor. I mean, you say it doesn't arise here for the reasons you've discussed, but assume, contrary to your case, that the decision was forced upon the company because they didn't have the relevant material. Why should that not come in under the Z factor?
Well, my Lord, here is how I would say that what is before your Lordship is that they had the data.
Yes, I understand that, and maybe we don't need to go into it. I mean, if you're right on that, it's the end of the story.
If it had come afterwards, they still would be constrained by whether those costs were incurred as a result of that.
Or is the position that they've got to wait till the next 5-year review, and unfortunately the system simply doesn't cater for a very exceptional item like this large back pay claim? I mean,
what does it cater for, Z, then?
The Z factor. Hurricane, the previous claim that they had made was when Hurricane Ivan had hit, and so
Yes.
they could not have...
I think I can think of things
Right.
which are
So
obviously not due to managerial decisions, but
right.
I mean, I wouldn't have to do with that.
Yes, because I think in one of the earlier submissions they said this was going to be $16 while the hurricane was, the Z factor was $11 already for the hurricane.
Yes.
So that was the example you gave.
Yes.
So the intention is to ensure that the company would not be at a disadvantage if it were to incur costs out of which it had absolutely no
Yes.
control.
Yeah, we understand that.
So you say the structure is you get it right by reference to the test year and that which you can predict at that time in your filing. Thereafter, you're constrained by Exhibit 1 broadly to inflationary rises subject to adjustments for quality of service and productivity, but broadly inflationary annual rises. And the exceptional factor is the Z factor, but it doesn't cover this. Yes.
It is the scheme, it is the regime, it is the license. It is what is in place.
And our task is to interpret the license.
And one's task is to interpret the license. But just to say that when one looks at it against the relevant principles, my Lord, we do not see any absurdity arising.
Well, supposing, I mean, you accept the managerial decision must, it must be the dominant cause, must it, of the event which leads to the increase? If you if you're in the process of constructing a building and it's hit by a hurricane, you accept that the event then is not due to a managerial decision to construct the building.
Well, the additional cost that you would incur would not be as a result of a managerial decision if those costs arose from the hurricane, out of which you have no control, over which you have no control.
Yes.
But if you knew, for example, the hurricane season and you're within the hurricane belt and you did not take the right steps to do critical parts of the construction within a time frame that would prevent you from that exposure to the winds, then certainly that would be at your peril. So you know that, for example, within our island, the hurricane season begins in June and it ends in October. You know the likelihood of what will come. You do not then set out to construct, and then when the hurricane comes, you say, well, it totally has nothing to do with any decision that I have made. And so I'm incurring additional costs, and I'm going to pass it on so that I do not have to bear any of it.
Yeah, well, it would be no doubt a strong case.
So had JPS been focused, had it not been so stubborn, had it not been so disregarding of the industrial climate, had it accepted that it was bound by the IDT award, had it accepted that it had the information and had calculated a structure, save and except that it was not the structure that was agreed on, it would have been able to include it in the 2004, and it would have been properly considered then. But perhaps its focus was elsewhere, as an
You would have been very happy if it had said in 2004, all these costs are costs we accept. We will be happy to pass them on to consumers, and they go into our price rise. There would be no objection to that.
Well, my lord, that would be a matter for the OUR to determine when it comes before it.
No, but that's the logic of your case, that's
Yes.
what should have happened,
Yes.
isn't it?
Because the cost, the consumer is going to be put to bear a cost which they could have borne over time. Time has gone on. People have different things to do. Other things have increased along the way. So to be saddled when you probably lost focus.
I can see that.
Because you're perhaps paying attention to other things elsewhere.
Yeah.
The mechanism is there. It's there. It struck a bargain with the license when it acquired the majority shareholdings, and it should be fully aware of it. But Mirant was seeing itself as separate and apart from the licensee and wanting to insert itself as the licensee, disregarding decisions that were made, and also not being sufficiently mindful of the decisions that would impact either its recovery or the burden that would be placed on the back of the JPS co-consumers.
Right.
So, my lord, we say that they were known, could have been measured, and they would fail there. But even if you find, for whatever reason, that there was some challenge, in the unlikely event that your lordship so find, then it is as a result of the decisions they made,
right,
which put them in the predicament to have brought it in the Z factor. Unless I can assist your lordship with anything else.
Thank you very much. Yes. Madam Director, thank you very much indeed. Yes.
My lord, may it please you. The learned Attorney General took your lordships to page 380 of the record. It's now on the issue of known and measurable. Will note that the learned Judge of Appeal started paragraph 61 with the statement that items 3, 4, and 5 reflected the union's concern, etc. Where the judge got that from, my lord, is from page 61. And if I could ask you to go to page 61.
Well, you can read them. It's obvious. 3, 4, and 5. Certainly 4 and 5 are quite obviously about the dispute of principle about which comparator you take.
Yes, my lord. And I'm going to show you, Your Lordship, why those items were chosen and why they report.
61.
Yep.
61. So 61 is in the IDT's report, lists the same items. IDT said 3, 4, 5, and 6, they added 6, are not relevant to the union's pursuit of equity, and so on. And the question arises, my lord, what's the difference between 1 and 2 and 3, 4, 5, and 6? And why did the IDT identify these? And I submit, my lord, that the reason is the IDT was concerned with the policy issues. What was the correct approach? And items 3, 4, 5, and 6 dealt with policy type, the issue that my lord uses referred to as the comparators. And that is what they focused on. If one looks at the other two issues, issue 2 seems plainly to relate to data. This is not a policy issue. Issue 2 says, and I cannot say, my lord, what R2 means, but it certainly appears to be some missing data. What the tribunal concerned itself with, what the IDT concerned itself with, were the policy issues. And hence their comments that followed related to those. The Court of Appeal, as your lordships have noted, made a comment about it being reasonable and there being no dispute about the IDT having considered the material that was before it. And it's important, my lord, to note that one matter in relation to which there is no dispute is that the KPMG report was not before what has been called the Electricity Tribunal. The Electricity Tribunal, whose decision is the subject of these proceedings, did not have the KPMG report. And so when it concluded that the OUR was right in saying that the appellant could have calculated this from the KPMG report, all it had were the comments that appear in the IDT report and the documents here. So when my learned friend points to the fact that various persons gave evidence before the IDT, that does not really assist the court, and indeed could not have assisted the tribunal, because not even the transcript of that evidence was before them. That, my lords, is the state of the evidence that the court, that this board needs to determine whether that was sufficient for the JPS, the Court of Appeal held, or even the committee to have calculated the amounts involved. My lords, we've already submitted that. In our respectful view, they were not. My learned friend, Dr. Barnett, took your lordships to the Labor Relations and Industrial Disputes Act. And he submitted, it was a criminal offense. And there was a binding decision, and the company ought to have implemented it and so on. I would observe, my lord, that this was not a point raised below. It was certainly not an issue before the tribunal. And had it been an issue, the appellant appellant would have been in a position to have led evidence to explain why it was that the unions did nothing. Your Lordships have observed that the unions did nothing to enforce the award. Because this was not an issue, no evidence was led as to why that was. And so one could hardly rely on this point to draw any conclusions from it. And I would say, finally, on this issue, that in any event, it doesn't affect the issue before the court, the two issues before the court. Was JPS in a position in late 03, early 04, to determine with reasonable accuracy the amount of the cost? One issue. And the other issue, the meaning of managerial discussions.
Yes, I mean, if the award doesn't itself determine with reasonable accuracy what the costs are, the most it can mean is that there was some sort of obligation to do it, get on and do it. It doesn't answer the question whether it was they were measurable with reasonable accuracy, I suppose. Yeah.
And if I make a final observation as to the intent of the IDT's award on pages 64 and 65. And the submissions have been made as to whether the committee's role was a mere recommendation or a decision. And there's an important difference, my lord, in my submission between the paragraph at the top of page 64 under the heading unnecessary provision and the paragraph at the bottom that says recommendation. In the former, the tribunal says, in making this award, the tribunal has decided that the oversight committee be reconvened, etc. That's a decision. That the committee must be reconvened, that the consultants must be a part of it, and that they should implement the award. The recommendation is that the implementation must have the guidance and expertise of both groups of consultants and so on. Now, to some extent, it's a duplication, but the point about the committee having a decisive role, I would submit, my lord, is clearly a decision, not merely a recommendation. And as to my learned friend, Dr. Barnett's submission, that their reason was because of concern about industrial relations, I would respectfully submit that it doesn't matter what their reason was. The fact is that the JPS could not have left with this award and simply ignored the sections to do with. And the one point at which I agree with my learned friend, the Attorney General's submissions.
Can I just ask you one question? We are here considering the decision of courts below on a judicial review application. The judicial review application is directed to the the Electricity Tribunal. And so necessarily you're accepting, are you, that it's their decision that's in issue? Can I just understand what your precise case is about their jurisdiction? Do you accept that they have you referred us to what they said about their own jurisdiction, but it seems to me not entirely unambiguous. Are they themselves only authorized to act if they form the view there's some error of law or fairness in the conduct of the office, or do they have a completely open hand?
I think they have a completely open hand, my lord. They certainly have a wider scope than merely error of law. But for the purposes of this appeal, the complaint was that on the material presented to them, the OUR's decision that the costs were known and measurable and would have been effective, that as required by the Z factor, as required by the license. That finding was not supported by the evidence put before them. So that whether it was limited to a judicial review or not, they certainly would have had the scope to have said that. And that is our case, on this issue. My lords, unless there's anything else. May I please?
No, just wait a minute. Yeah. Well, thank you very much indeed, Mr. Sutton. The board's grateful to all counsel who've appeared and helped prepare this case, and to the oral submissions which it has heard, and it will take time to consider what advice it will humbly tender to Her Majesty. Thank you all very much.